hold on 1 second. I'm just, okay, there it is. It started. I think we're ready to proceed.
Great.
No, there's someone that's missing. Are you waiting?
He couldn't make it for
Yeah,
this.
Derek,
Eric
that's
Curry, he couldn't make it for this.
Oh.
He already spoke.
Yeah, it was Mr. Curry.
Mhm.
Yeah.
Everybody ready?
City's
Yes, sir.
ready.
Yes, sir.
Mhm.
Excellent. Well, thank you for accommodating my schedule. I apologize for the inconvenience. Normally, we don't have to stop a hearing and then resume it. Mr. Bailey, are you ready to make your statements?
Yes, sir. Mr. Caldwell had a request.
Is it possible, so Mr. Bailey has a lot to say. Is it possible, or would anybody object if when he's done, he's able to ask Mr. Cotton any questions?
Just
And I have to
clarifying
go through me?
Yeah.
That's up to the parties. If they do not object, that's fine with me. If they object, then we'll decide the objection.
Yeah, I mean, the city would object. Mr. Caldwell is the petitioner here, and Mr. Bailey and Ms. Bailey are participants, but they're not the petitioner, so.
Understood. Mr. Cadwell, do you have any response to that argument?
It is, that's fine. It is what it is.
All right,
So
the
ready.
objection is sustained. Okay. Go ahead, Mr. Bailey.
Special magistrate, as complicated as this case may seem, the core facts are actually very simple, and I think you already get that. City council voted unanimously to remand this back to you because of two reasons. A lack of forensic evidence providing a chain of custody for the letter in question, which, as we all know, is necessary for a public record. And B, a review of other applications that were made by 717 back in 2000. And in response to those, we have all of the answers. The answers have been presented to us in evidence so far. So what we know is Assistant City Johnson Velez this last week stated in December 5th, we've received all available forensic records and no records, and I'm going to have to paraphrase because she was responding to an email question, supporting the claim that this letter was transmitted in the year 2000 wasn't found. So that's the answer to the first thing that City Council asked. The second thing was asking about the way in which responses were given to 717's other properties in 2000. We know that as well. We presented that evidence to you on Friday, showing that when people presented their request to opt out, they got a letter, or they got basically something saying excluded. It's a city form, and that corresponds with all of the other properties that they submitted. So we know these two things. That's the end of the road. That's the end of the story. But because the city is continuing to hang their hat and sticking to their story, I will continue. So since I can't ask Mr. Cotton any questions, I will say these as a statement. So Mr. Cotton testified in the last hearing and again today that the alleged letter was not in his review file for the August 17th decision. So his research was complete. He basically stated that his research was complete for that August 17th letter. On the same day, the city attorney supposedly sent the alleged letter to Eric Cotton. And as far as we can tell, because we've seen no emails to say otherwise, Eric Cotton didn't seek advice from the city attorney. Basically, Mr. Riccardi contacted the city attorney through the back channel. The city attorney sent information to Mr. Cotton and uploaded the alleged letter on August 17th. That's the beginning of it going into the public record, was August 17th of 2021. So the important reason why I'm pointing this out is because earlier today, Ms. Johnson Velez was pointing to the code giving Mr. Cotton the opportunity to consult with the legal department, which consult in this case is a verb, and it means that you're seeking advice. And we have seen nothing so far in email chains or communication showing that Mr. Cotton was seeking advice. Instead, he was delivered information after August 17th, which would be the end of the open record period. He also stated that the letter was determined valid, but the city has not provided any documentation from anyone saying how that was deemed to be valid. To the contrary, as I mentioned before, Ms. Johnson-Velez said that there was no forensic evidence saying that this letter ever existed in the city in 2000. So that it's my opinion that the special magistrate should be dubious of hearsay testimony from the applicant, who's made the repeated statement that these properties have been used for over 30 years as a parking lot. In the previous hearing, we presented evidence, 15 years worth of evidence that it had not been used as a parking lot. There's a gentleman that's going to speak in public comments today that's going to echo the same thing, I'm pretty sure. Also earlier today, Mr. Carty said that he did not know that there was a zoning issue with this property until 2021. The problem with that is his own letter, which was in Mr. Michelini's evidence from 2007, refers to the property zoned YC7 in error. So in 2007, Mr. Carty did know that this property had been rezoned and that there was a problem. Special magistrate, in your formal decision in the previous hearing, you made mention in your opinion of the uncontroverted evidence that Mr. Kirshner was aware of and did not object to the request in March 2000 to retain the original zoning classification. And I submitted to you on Friday evidence in the form of a signed letter from Mr. Kirshner at the very end, where he states that he does not recall having any conversations with anyone regarding zoning.
I saw that. That's exhibit I to your 10-page.
That is correct, sir. Yes.
PowerPoint.
And if you would like me to read that into the record, I'd be happy to. Otherwise, that's my presentation. And thank you for your consideration.
Thank you for your time, and thanks for coming back. Does the city have any questions of Mr. Bailey?
Yes, I do. Regarding the letter from Chris Kirshner, were the statements in the letter made under oath? Do you know?
I do not know that.
And is the letter notarized?
It is signed.
It is not under.
Letter notarized? Is the letter notarized?
The letter is not notarized, no.
Okay. And do you happen to have the email exchange? I just wanted to ask you to read into the record my exact response to your question number 3, or to Mr. Curry's question number 3.
I assume you have it.
I do have it. I don't have his original question, or else I would.
Good morning, Mr. Curry. This is a response to the 5 questions you posed in reference to the email as follows.
Well, it's really just question number 3, the regard to the forensic record, because I just wanted the exact statements that I made. Okay.
Sure. We have reviewed all available forensic records, and no records have been identified that are responsive to the request in your item number 3 of your email.
Okay. So in your testimony, you talked about how I said that we have no evidence that anything was submitted in March 8th of 2000, but that's not what I
said I had to
indicated, right?
paraphrase because I was responding to your email, which was referring to his email. I'm happy to.
Okay. No, I just wanted to clarify that. What I said was that we couldn't find anything.
I'm pretty sure I paused when I said I need to paraphrase, so I don't want to.
So you said we just didn't have the original question, so I just wanted to make sure that.
No,
right.
okay. And I'm just going based on your response.
Okay. All right. Thank you. And so your statement that Eric Cotton received the copy of the March 8, 2000 letter after he issued the August 17th, 2021 letter, was that based entirely on his testimony at the May 2022 hearing?
I missed the first part of what you're saying.
Your testimony that Eric Cotton received the March 8th, 2000 letter after he issued the August 17th, 2021 letter, is that based solely on Eric's testimony from the May 2022 hearing?
It's based upon that, and it's also based upon when he uploaded it to Acela, which we also included as an exhibit.
Okay.
There's no record of that letter in the public record before that time.
Okay. Okay. I don't have any further questions.
I have a question.
Oh, well, I'll have
Okay.
Thank you. Yes, go ahead, Mr.
Accardi.
McElhaney.
Cardy.
Accardi.
Oh, sorry, go ahead.
That's okay. Are you the petitioner or property owner in Ybor City?
I'm a property owner in Ybor City, but I'm not the petitioner. No.
Is the petitioner a property owner?
Is the petitioner a property? Yes.
How long have you been a property owner in Ybor City?
Since do I need to answer these questions, or is this germane to the conversation? Special
How
measure?
is this, Mr.
Well, I
Accardi, how is this
want to
relevant?
understand if he was a property owner. Maybe another question. Were you a property owner in 2000? That's my question.
I was a property owner in 2000.
Okay, could you just identify where you're a property owner?
Special magistrate, I don't understand
Well,
where this is leading
this'll
to,
go
or
somewhere.
why.
It's gonna-
why
Yeah, one second. So if there's an objection to a question, you can state that you object and what the reason for your objection is, and then we'll decide.
I object to the question because I don't see how it pertains to the matter at hand.
Okay, Mr. Accardi, how is it relevant whether he owned property 22 years ago?
Well, I'm just curious if Mr. Bailey, and I'm not sure Miss Bailey, y'all were together at that time, was a property owner in the same area, which I believe he was, that they did some rezoning in that area. Same situation, YC7 versus YC6.
We did discuss.
How,
before
if
the
I
hearing.
may, one second. So how is that relevant to this proceeding?
Okay, I'll withdraw my questions, no problem.
All right,
Just
understood. Do you have any further questions?
No, sir, I do not.
All right, thank you very much. Stephanie Bailey, do you still wish to make a statement?
I don't think I have anything to say that hasn't already been said for our side. So no, I don't need to speak.
Understood. Thank you. And Mr. Albergo, would you like to say something?
Yes, thank you. I'm somewhat late to the game, so if I am misunderstanding something, I apologize, and I'm certainly happy to be corrected. I'm a engineering professor at USF, and I owned an engineering firm in Tampa for over 25 years. Been a resident here in Tampa since I think 1979. My interest is I live across the street at 1913 East Fifth Avenue, which is just across the street from this lot. Now, as I understand, there's some sort of administrative confusion pertaining to the authenticity and efficacy and timing of a filing regarding a reversal of the current zoning at, what is it, 1916 East Fifth Avenue, I believe. And if I understand it correctly, the current zoning would not allow for a parking lot or that type of use that currently it's a residential zoning. So what I'd like you to know is I've lived there for several years, and it just so happens my son lives just across the alley at 1914 East 4th Street and also has a clear view of 5th Street from that location. Probably dating back now 6 years, I have never seen the lot in question used for parking until recently when there was a sign put up soliciting parking or parking for a fee that was placed along 19th Street. But before that time, I've never seen any cars parked there, and certainly not for a fee on top of it. Now, I've heard from this morning that this is not a parking issue, but a zoning issue. But frankly, I don't see how the two can be uncoupled. I mean, based on my background and experience, there's no doubt that the placement of a parking lot on what is clearly a residential lot, which I believe sets between two zero lot line residential housing units now, and in a clearly residential neighborhood, it's just not an appropriate use. Now, I understand there might be some administrative issues surrounding that, but based on everything I know, it's inappropriate to put a parking lot in the middle of what clearly residential housing in a residential neighborhood. Our experience over the last few months that cars were being parked there has not been very positive. Instead, it's been highly disruptive. It's dangerous to the residents at all hours of the night, and the litter and sanitation issues persist in the subsequent days. But probably my most significant concern is property value. I purchased my home with the understanding that this was a residential neighborhood, that there were no commercial lots to be used for parking. The rezoning to residential use was the correct decision, given the surroundings. If you allow a reversal of zoning, you are essentially impacting all of the neighbors to benefit one, and that's not equitable, especially under all of the uncertainty I'm hearing regarding the filings themselves. So I know I'm coming to the table late, but I trust that you will carefully review the evidence, including who owned this lot and when, and the timing and likely authenticity of any documentation offered after the fact. I acknowledge that 717 parking business is a necessary inconvenience for Ybor City. Still, it does not and should not reside where its business impacts the daily lives and property values of everyone else who lives in what is clearly a residential street, residential neighborhood, and purchased the property in good faith with the understanding that the lot was zoned residential.
Did he freeze on your end too?
Yes, he did.
I'll try to message him to let him know he's frozen. If I have that ability, let me look. So it says the meeting chat is muted. I don't know if you can.
Hold on one second. Let me
Sure.
see. Hold on. Let me. He may. Oh, okay. So
Yeah,
he
I
has
see.
to log off and log back in. So
Yeah, he's doing that. It looks like he left and he's coming back.
Did your plumber show? Did your plumber show? It's a great season.
Is that him? There we go.
Okay, let's see.
Welcome back.
Thank you. So was I muted the whole time?
No,
no,
not the whole time.
I was
you.
gonna say, I don't know if I could do it again. I was on a roll and I don't have anything written. At what point,
You essentially were cut off when you talked about how 717 parking business that
oh,
their
okay.
Yeah.
Yeah, I'd be happy. Okay. All right. So essentially, what I was saying is that the 717 parking business is a necessary inconvenience to Ybor City. Still, it does not and should not reside where its business impacts the daily lives and property values of everyone else who lives on this clearly residential street and who purchased their property in good faith and with the understanding that the lot was zoned residential. So a reversal would be entirely inequitable to everyone else.
Understood. Do you have any further comments, sir?
I do not. Thank you.
Yeah, thank you for participating, and sorry for the inconvenience earlier having to stop and restart.
No problem.
Do the parties have any preference on rendering basically a closing statement as to what they think the findings of fact should be with regard to the council's direction to me?
The magistrate, I think we had an opportunity to ask questions too, right?
Well, I'll ask the parties this. Mr. Albergo, everyone was under oath for this second part of the proceeding. I'm not sure if he was called as a witness or if he was just commenting as a member of the public. So I'll let you guys decide how you want to deal with that, if you want to question him or not. Let's start with the city attorneys first.
I have no questions for Mr. Albergo, but this is a separate, I would like to recall Mr. Cotton just to ask him just a few brief questions for clarification.
Understood. Do you have a position on whether or not a member of the public for this type of proceeding, which is unusual, different than our normal proceeding, can be asked questions by the representatives?
I don't have any objection if someone wants to ask Mr. Albergo a question.
All right. And let me go ahead and ask the petition. Do you have any objections, sir, to Mr. Albergo being asked questions?
No.
All right, please proceed then. Ask your questions.
Yes, sir. I had a question regarding do you understand the difference between a permitted use and one that is allowed by zoning?
Sir, I'm not an attorney, and nor am I. It's my expertise in zoning, so I would appreciate the clarification.
Well, my comments are related to your comments where you said that the use was inappropriate, where the use is permitted or was permitted previously. And we're arguing now about whether or not that should have been opted out.
I understand that. My understanding is that when the rezoning occurred, that after that time, there would have not been a permitted or allowable permitted use as a parking lot for that particular parcel. And that's what I purchased under. I had no understanding or belief that part of my community, specifically just across the street, it could actually become a parking lot.
Did you know at the time when you bought your property that the zoning was YC7?
I don't know that I knew the specific code, but my realtor, I asked these questions not only of the 1916 property, but I was also interested across the street where I live, next to the church, as to what would happen with that property as well. So I did make those inquiries at the time, and I was told that there could be no commercial use. I guess what I mean is a parking use. I did understand that those properties could be developed residentially.
Any other questions?
No. No, thank
All
you.
right. Thank you. Mr. Albergo, thank you for your comments.
I
Now we
appreciate
have
that.
the rebuttal from the city regarding Mr. Cotton's testimony.
Yes, thank you, Mr. Schroff. So, Mr. Cotton, you recall that you previously testified at the May 2022 hearing in this matter that you received the March 8th, 2000 letter from the legal department after you issued the August 17th, 2021 formal decision letter. Is that correct?
That's correct.
And was that a correct statement?
No, ma'am.
Okay, what is, in fact, you testified earlier today in this remand hearing that you received that letter directly from Mr. Accardi several months earlier in
Right.
April of 2021. Is that correct?
Correct. I received the email on April 12th, 2021.
And the contact that you had with the legal department after the issuance of the August 17th, 2021 letter is what reminded you that you had previously received the letter in
Right.
April of 2021. And so what steps did you take after you received that reminder from the legal department?
I uploaded the letters that were attached to this email. I uploaded them into Acela Then I met with my director and we discussed how to handle the next situation, if we should be reissuing the letter. And the determination was that we should reissue the letter with the findings that were in the August 30th letter.
And did you include, both the August 17th and the August 30th letter included the list of items that you took into consideration in
Correct.
reaching the decisions, correct?
Both was that whatever was reviewed.
Okay, and so the August 30th letter included this additional item that you remembered you had.
That is correct.
Okay. Okay, I have no further questions for Mr. Cotton.
Thank you. Is there any cross-examination?
I'd like to ask a question, Magistrate.
Please proceed.
Eric, were you satisfied that all the documents were timely filed in a form that was acceptable to the city?
Explain your question, please.
There-
What do you mean by form?
Well, that typically there's a format that the city follows, and I'm just asking you, were all of the documents filed in a manner that was acceptable to the city in accordance with the code?
The documents were all acceptable in the way they were formatted, yes.
And accepted by the city?
Yes, they were accepted by the city.
Were there general notifications provided to all of those property owners who opted out?
In 2000,
To your knowledge?
I can't speak to that because I was here less than a year at the time.
Okay, to the best of your knowledge, did Accardi follow the proper procedures as lined out by the city?
To the best of my knowledge, yes, at the time, my recollection, it was something that we continued doing for a while, was if somebody wanted to opt out of a rezoning for an area-wide application, they would submit documentation asking that to be included.
And you were satisfied with all the documents and that we've come to this conclusion that he properly requested to be opted out and his zoning should remain in YC6 per your letter and the other documents?
Based on my review of the documents that were submitted, yes.
Okay, thank you.
Thank you, Mr. Caldwell. Do you have any questions?
I do, yeah.
Yes, sir. Please proceed.
So is it normal, Eric? I mean, for somebody to send a letter in 20 years later to try to change zoning on something that okay, let's say it happened, right? They have a lot of property. You guys don't have a copy of this letter in the city anywhere, but then we just show up with our own letter. That's not how business is done in the city of Tampa. So has this happened before? Is this normal?
Specifically in something like this situation, no. It is the formal decision process is the process somebody would go through to try to prove a nonconformity or a vested right or whatever. At that point, that's when documentation is submitted to us. It doesn't have to be submitted. It doesn't have to be part of a public record. It can be other uses, the bulk directory for nonconformities, tax rolls for nonconforming lots and such.
Okay, I just find it hard to believe with so many lots owned that this one would go missing, and if that's the case, it sounds like not an Accardi problem, but a problem in the city of not filing it correctly,
Mr. Caldwell, do you have a question? Or further questions?
Yeah, I have one more question. Is there no bearing on the fact that when you get a letter like this from Mr. Accardi or whoever you got it from, that you don't do a fact check of did they own the property at the time? Is that something you don't even look into?
No, we didn't do. I don't go back and check tax records to see who was the owner at the time. Because this would have been the decision would have been reached in this kind of situation back in 2000. If assuming a letter was valid and is the correct letter, that decision would have been made that he was a property owner back in 2009 and 2022.
Okay, which it wasn't. Okay.
All right, thank you, sir. Any redirect from the city?
Just one question, Eric, is there anything that would, even if Mr. Accardi was not the property owner, would the city have accepted his letter on behalf of the property owner who he leased property from?
I honestly, I
You
cannot
don't
speak
know.
to what happened in
Okay.
2000. I'm not sure how that was handled.
Okay, I understand. But for a letter such as this, an opt-out type letter, is there any requirement that you are aware of that for an affidavit to authorize agent or some such similar form like you would require for a rezoning application?
Again, back in 2000, I don't have an answer. I can't redress because I don't know what the response would be.
Okay.
Then.
Okay, thank you.
All right, thank you, all. I have a question for Attorney Johnson Velez. One of the issues on the remand was that the city also provide testimony as to what happens in a case if the city cannot provide evidence that the document existed on the city side. What is the protocol? So is Mr. Cotton's testimony that absent some evidence to the contrary, that that document would be accepted even if it wasn't part of the city's records? Is that the protocol?
Want me to answer?
Right, if you could direct that to Mr. Cotton, I think.
Okay.
Yes, so there's testimony. Yes, Mr. Cotton, thank you.
Yes, when we receive for the formal decision process, when we receive information from the public on whether people are in support or not support of a request, we take whatever is submitted to us at face value.
Understood. So I think all the evidence adduced today and on Friday is sufficient to comply with the remand. I would ask that each side submit to me the proposed findings of fact that they think the council should consider in what was established today. What time period would the city like to submit that?
We have to go back. Let me look at the code to see when we have to do the,
Okay.
yeah, production fees.
And are you just asking, Mr. Hearing Officer, for additional findings of fact, or are you asking for a recommended order?
Now, I think, and you can correct me if I'm wrong, every side will have an opportunity to discuss this. I read it as, and I read the transcript of the hearing on October 20th. I also read what is attached as Exhibit A to the PowerPoint.
Yes.
And that seems to identify the specific tasks that I'm supposed to do, which is remand the order back to establish the chain of custody, get evidence as to whether it existed in the city, obtain evidence of other applications, the response to by the city of those applications, and then the protocol for this situation. So I think that's what I'm limited to, but if you disagree, let me know.
So, okay. No, I think that's what you're limited to as well.
Understood.
So.
So how much time would you need?
Mhm.
Today's the 12th, here's the calendar. So here's the 12th. You got 10 days. 10 days. Yeah. So that's the 22nd. That's when you- Okay.
10 days, is that?
Sure, that's reasonable. Mr. Caldwell, is that acceptable to
Yeah,
you?
That's fine.
And you can submit those to me in email by Word, and I will promptly review them. And there shouldn't be that much of a difference between them based on a lot of the uncontroverted facts thus far. But if there is, I'll resolve it and do so promptly. Thank you all for your time. Are there any closing remarks from anyone?
None from the city.
No, we're good.
No, sir. Thank you for your time.
All right. Thank you all. Have a great day.
Thank you. Okay.